We now turn to the second case on this morning's docket. That is case number 103400, State of Kansas v. Richard A. Jones.
If it pleases the Court, Chief Justice, I'd like 4 minutes of rebuttal.
4 minutes is granted.
Before argument, I want to draw the Court's attention to a particular phrase and paragraph in the opinion of the Court of Appeals regarding this matter, and that begins on page 2 of that particular opinion and ends on page 3. At the bottom of page 2, the Court of Appeals reviews that my client, the defendant, claims that the state was required to present evidence to support the pre-sentence investigation report. And then the Court of Appeals quotes subparagraph B of 2147.15, which is the focus, in my opinion, of our efforts here today and our objection to the Court of Appeals opinion. And I quote, "The summary of the offender's criminal history prepared for the court by the state shall satisfy the burden of proof regarding an offender's criminal history," end quote. And then, I think this is particularly crucial, the Court of Appeals says, "Here the state presented the pre-sentence investigation report and was not required to produce additional proof of what was contained in the report, all in conformance with 4715. And then there is a conjunctive sentence that says, "However, we note that a certified copy of the juvenile adjudication is included in the record of appeal." And I think that implies clearly that that was important to the court in making the decision. However, I want to note to the court and make it very clear that that was not present. That certified copies of that judgment was not present on the record when that sentencing hearing was convened.
What difference does that make, though? Because everybody admits that when it came to the sentencing hearing, there had been no prior objection to the pre-sentence report in writing as required by subsection C of the statute. And so the state's burden to do anything by a preponderance of the evidence was never triggered because there was no objection in writing. The objection was made orally. And so I can't quite understand why you frame the issue the way you have, because it's never triggered under the statute.
Well, very good question, Justice Biles. And in fact, in the Court of Appeals opinion, they never touch upon that. They never touch upon the fact that notice under subsection C was never given. They launch into other reasons why the state has performed its burden under the statute. So in a way, they have waived that argument or not touched upon it in their opinion.
I don't think so. I mean, it seems to me it's pretty easy. They're referring to subsection B because subsection B is the only thing in play, because the defendant didn't do what was needed to be done under subsection C to kick in any other burden. I don't see the way this is written as needing to do what you need it to do. So where am I wrong?
Well, I think you're wrong because at the hearing, there was no objection to the raising of the issue that the criminal history was not correct. And they moved forward during the dialogue between the court and counsel. They moved forward ignoring, essentially, that notice that was required. And what the court said was, well, we have no controversy here, let's move forward. But the dialogue between the defendant's counsel and state was to the effect, well, the defendant wants to make an objection, and state's counsel goes, well, we're not prepared to deal with that objection and prove up. We're not ready to prove up that particular record. So they moved forward as though they had waived notice.
Is there any authority anywhere that says that we ignore subsection B if the state doesn't object to an oral objection done in a sentencing hearing? I mean,
don't
that's
know
what
of
you're
any.
arguing for, and
Well, I'm
it seems
arguing
to go
facts.
contrary to the
I'm sorry.
statute. It just I mean, I can't get past the statute and how the defendant didn't do what the statute requires in order to object to the pre-sentence report in order to impose on the state the preponderance of the evidence burden that you're trying to put on it.
I know of no, to answer your direct question, I don't know of any precedent that says what you indicate.
Let me clarify. Are you challenging the existence of the Missouri involuntary manslaughter adjudication?
Well, I think that the thrust of the defendant's pro se motion certainly raises that question, maybe not artfully, but he raises that question as to whether or not the adjudication was appropriate. And there is language in the body of the copy of the certified adjudication to indicate that that was a child in need of care proceeding. I'm not going to sit here and tell you that eventually that isn't to be declared an adjudication.
Well, I see that as pretty critical here because you can stipulate to a fact, but you can't stipulate to what the law is. And so if his argument is that that can't be applied to the criminal history score, in other words, the legal effect of that prior adjudication in Missouri is not to increase the severity level of the crime, we have cases that say, hey, the parties can't stipulate to the legal effect of the actual convictions, but a defendant can stipulate to the existence of those convictions. And so I'm just trying to nail down what it is you're complaining about.
Well, I'm complaining about the fact that at the hearing itself on the sentencing, defense counsel says the defendant has an objection to the criminal history in two ways, a misdemeanor and then the juvenile adjudication. At that point, under the statute, I think it's incumbent upon the court to say, well, there's an objection. And state's counsel says, we're not prepared to prove that up today, or words to that effect. So what should have happened, the court should have said, well, we're going to set a hearing, and you have the burden under subsection C to prove that up in terms of the criminal history. And again, that's why I raised the issue of whether or not the Court of Appeals took the certified copy into account when it wasn't on the record. All you get is obviously a pre-sentence report with a sort of a laundry list of criminal history acts. But our point is this: once it was raised in the sentencing hearing, and nobody said, well, there wasn't proper notice. We didn't get written notice. So they moved on from that point. And once the court heard that, we have an objection, orally or otherwise. I think it was incumbent upon the court to set down a hearing, and the burden on the state was to prove it up. I mean, I think overall our point is in our profession, it's just as important how you do something as to what you do. And the statute lays that out, and it's mandatory.
So your argument is not the legal effect that would have come from the conviction. You're still arguing the existence of the conviction because you're wanting to stop the proceedings and force the state to prove the existence of the conviction.
That's what subsection C says.
Okay.
And then what happens? Let's say we adopt your position. What happens? The adjudication doesn't go away, does it?
No.
Its effect doesn't go away.
No.
does it? So
No.
what happens?
Well, you have a hearing, and if
Have a hearing, and it appears as if the adjudication exists in Missouri for the involuntary manslaughter. Under Missouri law and under our law, it can be utilized in determining criminal history for an adult adjudication. So what happens? That's what happens. We just go back and do it over again.
Well, I think that the state still has to prove it up by preponderance of the evidence. I mean, that's what the statute says, Justice Rosen. I think that you can't ignore the mandate of that particular subsection. Now, had they have said during the sentencing hearing, Judge, we didn't receive any written notice. Under the statute, we can't move forward. But that's not what happened. What happened was, we're not prepared to prove it up today, Judge. So the judge says, well, let's move on.
Do you know when the parties got the pre-sentence investigation? And I know it varies from district to district and case to case, but do you know if they just received it at sentencing or if they had it a week before? Do you know any facts?
I don't, Judge. I'm sorry. That's our argument, Judge, if I...
No further presentation, counsel?
Pardon me?
No further presentation.
No, that's correct.
Do
Thank
we have
you.
any further questions of counsel? Thank you.
Thank you.
May it please the court, the state of Kansas appears by Stephen Obermeyer. If I could pick up with where Justice Rosen left off, and that is what happened at the sentencing hearing. The pre-sentence report is dated June 1st, that's when it was completed. I did not have a copy of the date of the sentencing hearing, so I can't tell you how much time that was. But from my reading of the transcript of the sentencing and motion for a new trial, they conclude the motion for new trial. The trial court, Judge John Anderson, asks if we're ready to proceed with sentencing. I show the defendant is criminal history B, and defense counsel says, Judge, we have no lawful reason beyond what we've already litigated in this case to proceed with sentencing. And then then the attorney says there's a couple of other issues. Mr. Jones wishes to challenge the priors 1 and 2 that don't affect criminal history. And so Judge Anderson did not think it was a justiciable issue since it didn't impact criminal history and proceeded with sentencing. That turned out to be incorrect because it would have the juvenile prior adjudication made Mr. Jones category B instead of category C. So that prompted a 1507 action by Mr. Jones against sentencing attorney, claiming ineffective for not filing a written objection because there was not a written objection filed. As I read the Court of Appeals, that opinion that there was no need to prove criminal history because a written objection to the criminal history was not filed in the district court. And I cited State v. Sykes as a case that says you have to file a written objection, which is what the statute says. You have to file a written objection to the criminal history score, and that's why the prosecutor wasn't prepared to prove the juvenile adjudication from 1992.
Can the state waive that written notice?
I don't think so.
Why?
Should the state have objected?
Well, no. My narrow question right now is technically the statute says provide written objection before the sentencing, but if defendant shows up and makes an oral objection, can the state waive the requirement that objection be in writing?
I think you need the state saying we waive.
No, the question is, can the state waive that? Not how. Can the state waive that requirement?
I think it could be waived.
Okay.
I don't think it was waived in this case.
I understand that.
And the statute also says, even if it is waived, 4715C says the sentencing judge shall allow the state reasonable time to produce such evidence. So if Mr. Jones wanted to stay in custody in Johnson County longer, we could have set it over 6 weeks to go to Jackson County and get the juvenile adjudication form. But there was no written notice of any error filed. It was first raised at sentencing, and the way I read that is defense attorney maybe didn't think it was an issue, but my client wants me to raise it. So that's why it's being considered. So a year or two later, we're at the 1507 proceeding, and defense counsel testified, yes, I should have filed a written objection. It would have made a difference. The same trial judge found that the performance prong, there was a violation of the performance prong of the ineffective assistance of counsel test. However, there was no prejudice because at the 1507 hearing, the state offered the judgment and the adjudication that would have made him a criminal history B. This was raised in the direct appeal in the 1507 case, which is in the appendix to the blue brief. As I tried to point out that this issue had been considered, that eventually the court got it right because we did have a hearing where this prior was proven at the 1507 hearing, and it would not have made a difference. The Court of Appeals opinion is in the appendix, and the court affirms that, affirms the failure to file criminal history at pages 11 to 12 of the blue brief in the appendix. And the Court of Appeals declines to consider the motion to correct a legal sentence because of this case here that's pending. So I think the issue has been addressed, and that there shouldn't be another bite at the apple in this motion to correct a legal sentence case. I think the only other thing I have to add is the fact that the petition has the terms child in need of care does not make it a child in need of care petition. There's no reference in that judgment to the parents being on some sort of reintegration plan or having to do anything to help be united with the child. As the court knows before the LM case, that the purpose of juvenile offender proceedings was the parents' patrie in the best interest of the child, and that's what was going on back in 1992 when the judgment in juvenile court in Missouri occurred. And additionally, I don't think that issue has been briefed just by putting quotes around adjudication and criminal. It's not briefing that issue. So I think the Court of Appeals got it right in this case, and I would ask you to affirm the Court of Appeals. Thank you.
Do you have any further questions of counsel? Thank you, counsel.
Thanks.
You'd reserve 4 minutes for rebuttal.
I won't take that long, Chief Justice. What you've heard from Mr. Obermeyer was exactly what we have advocated in front of this court, and that was that you can waive written notice. Mr. Obermeyer admitted that it was possible to do, and that's what we're advocating here. It was in fact waived. The judge had the responsibility under 4715C to convene a hearing, whether it's 3 minutes long or 4 minutes long or 30 minutes long. The statute directs the court to convene that kind of hearing, and the state is obligated to prove up the criminal history. That's the statute, plain language. Mr. Obermeyer now confirms that you can waive orally that notice. That's all I have, Chief Justice. Thank you.
Any further questions of counsel? I see none. Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. This time the court is in recess for 15 minutes.